Hello, my name is Michael Tesoro and I prepared this presentation on ACCC compliance programs just to set out what you need to do to develop a good program and some of the things to avoid when you're putting one together. A bit of background about myself. I might go in reverse order. Prior to setting up my own business, Tesoro Consulting, I worked at the ACCC in a few different roles, and one of the roles was as a Director of Enforcement. And when I worked at the ACCC, we would often be given a compliance program that a company had prepared as a consequence of entering into our 87B undertaking or court orders. And we would go through and we'd check the compliance program, make sure that it had all the proper elements in it and provide the company with feedback. But a few years ago, the ACCC moved away from this sort of service, I guess, and required companies to hire independent reviewers to do that same function. So since I've set up private practice, I've been retained by quite a number of companies to be their independent review of their compliance program. A few of the companies I did work for there, Aldi, Airbnb, LG Electronics, Dell Computers and Thermomix. And the way it works is there might be a 87B undertaking or a set of court orders, and those documents require the company to establish or to update their compliance program. Often they hire a company to develop that program for them. And then after it's been implemented for about a year, then the independent reviewer, myself, comes in and reviews the whole program, makes sure all the elements that are required have been implemented, but also try to get a feel for whether the program is effective. And previously I used to prepare reports, one for the ACCC and one for the company. In recent times, I only have to prepare one report and provide that to the company. However, if a company fails to do an important aspect of the compliance program, say forgets to do training or something, that's considered to be a material failure, and I'm required to report that failure to the ACCC. I've only had to do that once in about 50 independent reports, so that's a rare occurrence. So outlining the presentation, I'll start with a quick introduction, go through the elements of a compliance program with a particular focus on the ACCC programs. A lot of this is fairly generic. It's based on an Australian standard, but the ACCC has a few things that it requires in its compliance programs. To talk a bit about continuous improvement, it's very important to have measures in place to continually improve your compliance program. It's not a case of set and forget. Talk a bit about independent reviews. As I said, I've done a lot of that work and provide a few insights into the way that process operates. And then finally, some conclusions. So the ACCC Guidance and Compliance Program is fairly limited. You go to the website and there's a couple of pages of information, which is fairly generic. But the thing that's of more interest is the 4 templates on the website of different types of compliance program. There's tier 1 through to 4, and they increase in terms of detail and sophistication. So tier 1 template really is for a small business, a family-owned business. It has very basic requirements, and that escalates to a tier 4, which is probably the type of compliance program that large companies, listed companies should be looking at implementing in their businesses. So obviously the first step in establishing your compliance program is to appoint a compliance officer. And I think the main factor to look at there is the level of seniority. It's not so much a case of the level of expertise they have, it's really that they're of a sufficient seniority in the business that if they say something to the board of directors or the management about a problem, they will be listened to, they will be taken seriously. And there's also an element of a person who is not fearful of telling the senior management bad news, somebody who has a certain robustness in the way they're willing to identify problems in the business. Having said that, I think it's a mistake to appoint your most senior employees the compliance officer. Some companies think that it's a good idea to appoint the managing director as a compliance officer, but I think that actually is a bad idea for the simple reason they're very busy people and they won't be able to devote the time they need to the role. So it's better to have a senior manager, but not at the very senior level of the business. Also, when you do appoint a compliance officer, it's really important to send them a formal letter, not just to sort of tell them morally that they're the compliance officer or shoot them an email. You really should send them an appointment letter which spells out their duties, what they're expected to do in the role. So that's a very important element of it, particularly if you're ever called on to prove that you appointed the compliance officer on a particular day and you explain the role that the compliance officer had to fulfill. Now, it's interesting, the role of the compliance officer. There's different models, and the model I see often is of a compliance officer who will be responsible for a broad overview role of the compliance program, and then will use the resources maybe of an external compliance advisor or expert on a number of other issues. So, for example, companies may appoint their general counsel or in-house counsel as a compliance officer, and they have responsibility for reporting to the board, preparing policies, but then the external compliance advisor will be responsible for preparing a risk assessment, providing training, keeping the business up to date on legislative changes. So it's a model I see very often, and I think it works very well. You really don't want to be necessarily spending all the money to train up your in-house compliance officer to become a total compliance expert. They're people who just do that as a day-to-day job. So having this sort of mixed role is a model I see that's being used increasingly, and I think it's a good idea. Also, on occasion you need to change the compliance officer, and often it's done for reasons that are legitimate, that the person's not working out in the role or for some other reason. But whenever you change a compliance officer, it's very important to document it very thoroughly, just to avoid any suggestion that the compliance officer may have been removed from their role for bringing bad news to senior management. So it's very important to be totally transparent when you do change a compliance officer, particularly in the context of an ACCC mandated independent review. The independent review will want to know why the compliance officer has been changed from one year to the next. Then once you've appointed your compliance officer, it's important to issue a compliance policy. And I think the content of the policy has to be got right. I think the main thing is to really focus on the key issues, not to have too much detail. It should only be a couple of pages long. The broad overarching principles that you're going to be applying in the business. It should have a statement that you are committed to compliance and how you're going to achieve that. I think the main thing is, once you have developed a policy, you should launch it formally, and that should be launched by the board of directors or by the managing director. It should be launched at a very high level in the organisation, and that just lends a lot of credibility to the policy and demonstrates to people that it is important. You're just not ticking a box. The other thing is, once you have launched the policy, you should keep records of having distributed to all staff, because sometimes when a breach arises, an employee says to the ACCC, well, I never knew what the compliance policy was, I was never given a copy, and the company's scrambling around to try and prove that they gave the individual a copy of the policy. So you've got to be very careful that you can prove that the policy was emailed to all the employees and have a list of that and the date it was sent to all the staff. Obviously, once you've implemented the policy, you've got to ensure you train people about it. You've got to tell people about what the policy means and explain the key elements. I'll come back to that a bit later, but training about the policy is really important. Also, when you're looking at an ACCC compliance policy, they actually mandate a few things which they believe should be in there. Some are lifted straight out of the Australian standard, but others are their own particular requirements. Clearly, there should be a statement of commitment to compliance with the relevant legislation, in this case the Competition and Consumer Act, but it could be the ACL, the Australian Consumer Law. But it needs to be a statement often made by the board of directors or by the managing director that there's a strong commitment to compliance with the relevant legislation. But it's also important to have an outline, you see 6.2 there, of how that commitment's actually going to be realised. So it's no point just making a motherhood statement about we're committed to complying. You need to put some flesh on that and explain what steps you're going to be taking to show that commitment. Thirdly, you need a clear requirement that all staff are expected to report any compliance issues that they become aware of to the compliance officer. So that's got to be in the policy and strongly reinforced with the staff. Also, there has to be a whistleblower protection provision. Make it clear that anybody who does blow the whistle on relevant issues won't be prosecuted or disadvantaged in any way. And finally, that there needs to be a clear statement that disciplinary action will be taken against anybody who knowingly or recklessly breaches the relevant legislation, and they will not be indemnified. So what all that means is that staff need to know what the mental element is for them to be liable. And this is important because for an individual to be liable under the Competition Consumer Act or the Australian Consumer Law, has to be a mental element, knowingly or recklessly engaged in illegal conduct. The thing you want to avoid is your staff thinking that they could potentially be liable for an accident or a mistake. And I've come across that before. The risks of that is that if people think they can be liable for an accident or mistake, they might just totally panic in their role and refuse to do anything. So it's important to explain this point to your staff very clearly so they understand precisely what they have to do. And secondly, you've got to let them know that the company can't cover them, can't indemnify them financially for any penalty or legal costs which they have to incur in fighting an ACCC case. And that's a really important bit of information to have. I think the interesting thing about this is obviously it creates a lot of fear amongst employees because the idea of trying to fight the ACCC out of their own personal financial resources is a very scary prospect, but it also gives staff an opportunity to push back when they're being forced against their will to engage in questionable conduct. So, for example, stories of people being told that they should engage in price fixing activity, and if they get caught, the company will look after them. Well, the employees know now that that can't happen, so they can push back and say, well, you can't look after me if we get caught for price fixing, so I'm not doing it. So it sort of works a bit both ways, I think. I think an important thing to do if you're a larger company is to conduct a risk assessment of your business, and you really should do that at the beginning before deciding on what elements your program is going to have. Now, the scope of the risk assessment ideally should be the entire business. Obviously, if you're subject to an A7B undertaking a court order, you may be limited to the breach that you've got to sort of look at, or looking at consumer protection issues if that's the particular breach you're in trouble for. But if you're doing it voluntarily, I'd strongly recommend you do an entire across the business competition and consumer risk assessment. The question is who's going to do the risk assessment. I guess what I think here is you need somebody who understands the business. Like clearly you may want somebody independent, say a compliance advisor, bring them in, do an assessment, but it's somebody who has to understand the way the business operates, the way you interact with customers and suppliers. If you get somebody who doesn't understand the business, you will potentially end up with some recommendations that are not practical at all and will really not work. I found that a few times that some risk assessors make recommendations which are just really not going to work. For example, one risk assessor told a company that they should endeavour to train all the staff in their manufacturing facilities overseas about the Australian consumer law, which is quite a remarkable recommendation given that only a small amount of the products coming from these overseas manufacturing facilities were going to Australia. So that was a recommendation which hadn't been well thought through. So you want people who understand business and will make recommendations that are sensible. Also, once you've got the risk assessment report, you want to prioritise the risks. So work out which are the most important risks, the most devastating consequences on the business and most likely to happen, obviously the ones you look at first, and then create a timetable of completing all these recommendations from risk assessment over a period of time. And I would say that a 3-year period is probably the ideal time period to sort of work through all your risk assessment recommendations, particularly if one of the recommendations is to rewrite position descriptions. That can be a big job, and that'll take you at least 3 years to do. So timetable everything. The other thing you have to be conscious of is that if you're going to send a person off to look at your business and find out where all the problems are, you want to be conscious of when they find something that there's some privilege attached to that. So however you manage it, you've got to ensure that you're not creating a document which, if the ACCC get their hands on it, is going to be a roadmap to every breach you've engaged in. So you've just got to either use a risk assessor who has a legal qualification and accordingly can provide privileged advice, or that report's being prepared for consideration by your in-house legal counsel, but be very conscious of the privilege issue. The next step is training, and I guess there's 2 ways this can operate. The ACCC mandated training under the compliance program is usually annual, and unfortunately, due to the BMW case, the training has to be limited to the issue that was the subject of the breach. So you end up seeing compliance programs which will train the staff on one provision of the Act, the provision that the company breached in the past. And so you may get 3 years of training on section 29(1)(m) of the Australian Consumer Law. And I can tell you, after 3 years of training on that provision, people are pretty bored stiff with that provision. So clearly, if it's a mandatory compliance program, try and broaden it out a bit. Don't just do the one section or 2 or 3 sections. Try to give a good overview of the relevant legislation. If you're doing it voluntarily, you've got a lot of scope to cover a wide range of issues, and you really got to be careful to identify the issues that are problematic, preferably from your risk assessment, and prepare training on that. Obviously, your trainer needs to have expertise in the subject matter, and particularly if it's a mandated training, the ACCC is going to want to know who the person's doing the training and that they are qualified. Also, I think it's important to tailor the training so that it fits the relevant people. So sometimes companies decide to train everybody in the whole organisation, but then you end up with the lowest common denominator set of training. It's much better to sit down and work out which specific individuals in your organisation need training on specific issues, and to develop training for those specific groups. So you'd have one set of training for your call centre staff. You'd have a different set of training for your buyers. You'd have a different set of training for the people who may be preparing bids for tenders. And you'd be looking at different issues. So with your call centre staff, you'd be looking a lot at consumer guarantees and representations and maybe even product safety type issues. With your buyers, you'd be looking more at misleading, deceptive conduct and also potentially cartel type conduct. And then with your people who prepare bids, you'd be looking at the bid rigging provisions of the Competition and Consumer Act. So better to train a smaller group of people intensively than to train everybody at a very high impressionistic level. Obviously, accountability is very important. There's no point training somebody unless you've got a record of when they got the training and what they were trained about. So make sure you've got sign-in sheets to show when people receive training, or a digital sign-in sheet, but some paper record or some virtual record that you can provide to the regulator to prove people got training. And also, if people miss training, make sure you chase them up. There's nothing quite as bad as somebody engaging in a breach of the law. When you go back and check the registers, you realise they missed all the training. So you want to make sure that there's a clear process in place to provide catch-up training for people who miss training. And with frequency, as I said before, if it's a mandated ACCC thing, once a year is mandated. But I think really you sort of be looking at providing training at the most effective time of year. And I always think the most effective time of year to provide training on ACCC stuff is around February, March, because the ACCC, as most of us know, issues an annual compliance and enforcement priority list. They telegraph what they're going to be focusing on in the coming year in a document. And so if you aim your training at the beginning of March, say, you can spend some time looking through the priorities for the ACCC and highlighting those and seeing if you're on the hit list for the coming year. And if you are, then maybe you want to schedule some additional training. One other thing about training is it's really important to spend at least half an hour at the beginning of the training going through the compliance policy line by line. You need to explain every element of the compliance policy to your staff every year. You have to reinforce all the messages in the compliance policy with all staff. Now, complaints handling systems can vary. There's often very, very sophisticated complaints handling systems, big databases with large call centers, and then you've got very rudimentary ones. But clearly the requirements of complaints handling system are all the same, essentially, as set out in the relevant standard there. They've got to be transparent, they've got to be efficient, responsive to people who want to complain, free. So there's a number of elements there that characterize an effective complaints handling system. You've got to make sure you tick all those boxes. And so designing your complaints handling system is important. You have to work out how many complaints you get, what sort of system you need, whether you need to invest in a tailored CRM that can deal with things, or whether you can get an off-the-shelf product, or whether if you're a small company, whether you've got to work out some manual system based on spreadsheets. So it's really important to be able to design it properly once you appreciate the scope of it. Another important thing is you've got to be collecting metrics about how your complaints handling system is performing. Now, if you're not collecting metrics, you've got really no idea how you're doing, how many complaints are being closed, how quickly they're being closed, how many are remaining open, what the types of areas are that you're getting complaints in, whether the number of complaints in a particular area has escalated over a particular month and then declined. You need to be measuring metrics. And the thing about metrics is that you need to identify what metrics are the most meaningful for your business. That involves sitting down, talking to staff, working out the most important metrics, and then reporting on the same metrics every month. I came across some companies that would change their metrics. They had a very sophisticated system which allowed them to measure all sorts of things, and they keep changing their metrics. That's not a good idea. Once you've decided your metrics, stick with those. You can add in a new one here and there, but don't change your core metrics. Stay the same. In terms of reporting, if you're generating reports that show metrics, make sure they go to somebody who understands what it means and is in a position to implement various strategies to address the systemic problems that the reports may be showing. I had some instances where there'd be metrics generated in a report and the report would be sent to the buyers, and the buyers sort of scratched their head and said, well, what's this? So make sure it's going to the relevant people who can understand the information. The compliance officer obviously should be getting a copy of these reports, but any other staff members who are in a position to change practices to address problems identified in the reports. Also, I think it's worthwhile to include some summary version of your metrics in reports to the senior management or the board of directors. They should be seeing just the volume of complaints, how you're doing in that area. It's important for them to have that knowledge. And finally, continuous improvement is very important. There's no point setting up a complaints handling system and just leaving it. You've got to be looking at ways of improving it, whether that's creating workflow documents, cheat sheets, better guides. Another thing that's very important is where you're in a position where you're recording calls with call center staff, that you actually have a process of senior staff listening to some of those calls and identifying problems that might be systemic. So the same call center staff are giving wrong advice or not being clear about specific issues, and then if you identify an issue like that, you provide training to the team, or if you identify a person who doesn't quite understand an issue, that you provide them with individualized training. So you've got to have a process where you keep monitoring how you're performing with the provision of, particularly of telephone advice, also looking at documentary responses to complaints. So if you do a lot of live chats, review those texts periodically at a random basis. If you're sending a lot of emails out or correspondence out, make sure you're reviewing those randomly, periodically, and try to identify problems. And obviously, keep records of all these steps that you're taking, because you may want to verify later on that you have been trying to continuously improve your complaints handling system. It's very important to have whistleblower policy, probably for two reasons. I guess the legislative requirements apply to a lot of companies nowadays, so required to have a policy in place. But the ACCC really expects companies to have whistleblower policies, and really it's a fairly simple process, because all you've got to do is really use the Australian standard there and use that as a guide. I think the main thing is, once you've developed a policy, launch it. Get your senior management, board of directors to launch it in the business, and so people realise it's important, that it's something that it should be second nature and not something to be feared. I guess the other thing is that accountability. So, when you're blowing the whistle under whistleblower policy, there's a escalating series of reportings. But at some stage, you're looking at maybe the managing director or the board members, a complaint about them. So you have to have some external complaint body that those type of complaints can go to. And there are a number of businesses in the market nowadays, often staffed by former police officers, who will provide a service in the whistleblowing context. That could be the external body that a complaint is reported to, and then you can retain those people to conduct an investigation, prepare a report. So you need some external mechanism where people can go if an individual wants to complain about the most senior people in your organisation. That's really important. Induction is also a really important area. The ACCC often requires this as part of its compliance programs. Clearly, you've got to set up a clear policy and procedure, and that means you've got to sort of be talking about who gets what level of induction, how soon after they start do they get it, and I guess what issues are dealt with. So you can have a general induction for most staff, but again, it should be tailored. So if you've got a person starting the call centre, there'd be probably a pretty clear level of induction that they would receive. But where it gets a bit more unclear is where people are employed in sales positions or employed in the bidding team or some area like that. And so really you want tailored induction materials to people working in those different higher risk areas. Also, I think it's very valuable when you're inducting a senior employee, like a senior buyer or a marketing manager or something like that, that they have a session, one-on-one session with your compliance officer, where they really talk through things in a great deal of detail and go through the compliance policy and do all that. So a couple of hours, an hour or two with the compliance officer on starting their job for these people in these key risk positions is strongly advisable. The other thing is how soon after they start, and a simple answer to that is very soon. You often came across situations where individuals would start a week after the annual induction training, and then they go a whole year without receiving any induction training. Really, you've got to be inducting everybody within a couple of weeks of starting, particularly if they're in these key risky positions. So you can't be waiting for the next round of training. It's more resource intensive, obviously, to provide this training as needed, but you've just got to do it. And again, accountability. You need to be able to prove when somebody received their training and what they were trained about. And this is obviously, if you have a problem with the ACCC and there's an individual who's done the wrong thing, you want to be showing the ACCC that you did everything possible to give them the instruction they needed as soon as possible. And so the person has ignored all that, but you've taken appropriate steps to ensure they receive the induction they required. Now, another important thing is that the compliance officer is reporting to the senior manager of the board regularly. And that's important, that the compliance officers at a level of seniority where they can actually go to the board and report to them about the compliance program in a certain amount of detail. And also frequency, like the ACCC often requires a once a year report or twice a year report. Really, that's not enough. Like, really, you'd be expecting the compliance officer to be including something in the board papers at least once a month about compliance. And that'd include details about what steps have been undertaken to implement the compliance policy, how's the organisation going implementing the recommendations from the risk assessment, has training been provided, are there any new legislative changes that the board of directors should be aware about. Also, how's the complaints handling going? What's the complaint levels? Are they going up or down? Is the metrics that you've set to measure performance, are they being met? So that's the content of the report. It shouldn't be too long. I think you'd be aiming at 2-3 pages maximum, but you should be providing that level of detail to the board of directors or the senior management, I think, on a monthly basis. And as I said earlier, the risk assessment is really key to sort of say, we've done a risk assessment 2 years ago. This is where we are in terms of implementing all these recommendations. The plan is to have it all finished in 3 years and then maybe conduct a further risk assessment at the end of 3 years. Now, the role that I've done a lot of is independent reviews, and the way it works is the company gets in trouble with the ACCC and basically signs 87B undertaking a court order and is required to implement or update the compliance program. And usually it's a law firm or a compliance professional is brought in to help the company design a program and implement it. And after a year of operation, I am brought in to review the program and make sure that the bits that have been included in the undertaking or the court orders have been done. So there's element of ticking the boxes, but also to get a feel for whether the program is effective. And the best way to do that is to interview staff. So what I tend to do is interview a number of staff, depends on how big the business is. I interview them confidentially, often over the phone, and ask them a series of questions about their understanding. I ask them questions about the culture of compliance and also gaps in the way that compliance is being handled. So what I seek to do is include a lot of quotes from the interviews. Being an ex-ACCC officer, tend to be able to take pretty good contemporaneous notes and include that flavour for the understanding that people have of their obligations, that they see as a shared obligation, that they don't have fear about various elements of their personal responsibility or liability. But I think the main thing about the independent reviews is that, it's a very good way to find out if there's a failing in your business that needs to be addressed. So the independent reviewer should be able to come in, look at the business and point out maybe some small technical problems or something larger, say an individual in the business who may not really be that switched on with compliance or didn't understand some of the key issues or seem to have maybe a dismissive view about compliance. They're the kind of things that independent reviews should be able to identify and really tip off the company about those individuals, because that's the biggest risk that companies have, is a rogue employee coming into the business and really seeking to work around compliance systems. And I guess if an independent reviewer gets a feeling that there's a person who is a rogue in the business, it's incumbent on them to sort of let the company know. And I have done that on a number of occasions. Like, I remember once there was an individual who I was supposed to interview each year for 3 years, and each time he found some reason not to talk to me. And that set off some alarm bells. So you really got to be in a position where you're looking out for individuals who may be too busy in their role, don't understand key issues about compliance, or just don't seem to take it seriously. The other thing about independent reviews is that I guess the ACCC doesn't get copies of the reports anymore. That's what they used to do when the process started. But now the way it works is that if an independent reviewer finds that a company has failed to complete one of the key obligations under its compliance program, that's considered to be a material failure, and the independent reviewer is required to report the company to the ACCC. And in all the years I've been doing this, 13 years, about 50 reports, I've only ever had to report one company for failing to undertake a risk assessment in the relevant period. So that's the way it sort of operates. The other thing about independent reviews that's really important is that there have been instances where the ACCC has asked or demanded a copy of the independent review report and then rejected it. And the main reason it gets rejected is because it isn't clear how the independent reviewer arrived at their conclusion. So they haven't explained the evidence on which they reached the conclusion that the compliance program fully complied with the company's obligations. So it's very important that all the evidence that the company has provided the independent reviewer is listed in the report, that the individuals who you've spoken to are listed in the report, and the inclusion of quotes lends further weight to the fact that there's evidence for the conclusions reached. So if you do hire an independent reviewer and you get a report which is 5 pages long and just makes a number of conclusions that everything's fine, you could potentially have trouble with the ACCC because they could ask you to redo it. And that's what happened in this other case. The company was hired an independent reviewer. The evidence wasn't apparent on its face, and they were forced to redo the whole thing at considerable expense. So independent reviews are very valuable. I think that whilst under 87B or a court order, you do independent reviews each year for 3 years. If it's a voluntary situation you're in, it's much better to really do an independent review every 3 years, I think. But the ACCC expects once every year for 3 years and then effectively never again. It would be much better to do one every 3 years and continue that into the future and make sure your system is working well. So that's all I sort of had about compliance programs. I guess it's important to make sure you don't make some of the mistakes with your compliance program, that you don't sort of appoint a person who's too senior and too busy to be a compliance officer, that you share the work out, you don't seek to do it all yourself, that you empower all staff to take on compliance responsibilities themselves, that you also ensure that you do regular training, that you do regular reporting to the board. And I think independent reviews are essential because you need somebody to come in and look at the program and identify potential problems. So I think there's some hints about the way to approach a compliance program. If you have any questions, feel free to give us a call or drop us an email. Bye-bye.